your host, Gary Austin.
Hi, this is attorney Gary Austin, back answering your family law questions related to child custody, divorce, and other family law matters. Today's question is, what factors do courts consider when making child custody decisions? In California, there is no bright line rule. Even the family code will tell you that there is no specific factors, and they give judges what the courts call the widest discretion possible. So that may not answer the question, but I'll give you what I've seen in my experience. It's the best interest standard, what's best for the child. Some of that takes on family dynamics. Some of it is environmental dynamics. Usually I'll tell you something that they don't necessarily consider, at least courts can't say it, are financial dynamics. So finances usually won't move the needle too much. The court's answer is that's a child support issue, and one or both of the parents should be contributing financially to ensure that the child has the best life in both parents' home. Another one that sticks out or stands out here in Southern California in particular would be distance between the two parents' home. The further and further the parents live from one another, I'd say once you go beyond 30 minutes, could be maybe a little longer. That changes the dynamics for most school-age children. Courts are going to be primarily focusing on, is it going to impact the child's education? Anyone here in Southern California knows our traffic is horrible, and there is a real possibility that courts don't want to see children sitting in the back of a parent's vehicle going for an hour or two before they get home. So that's one. School location also fits right into that. They don't want to disrupt academic activities, extracurricular activities, and that is why you typically will see one parent with a weekend schedule because they want to leave the weeks free for children to be in school and be educated. Other things may be work schedule, depending on the party's work schedule. If they have a flexible work schedule where one, for example, can get to school and pick the child up and cut down on travel time, that'll be it. They'll look into other environmental factors, who are around the children, extended family, things like that. But there is no clear-cut specific answer. Each case depends upon its own dynamics, and that's why the judges have the wide discretion to make the decisions that they do that are supposedly in the best interest of the children. There are arguments that could be made around all of these. I've had times when I have convinced judges to, in fact, let a child travel during rush hour traffic just because that is what the parties have been doing. And there was a time to allow one parent to bond even during the driving. I had a judge allow that. So there are some things that can be worked with, but typically you want to speak with your attorney, do some research, and try and put together a plan that puts forward as many positives and removes as many obstacles to doing what's best for the child and giving the child the best chance to spend as much time with the parent as possible. If you have any questions or you want to work with our office to try and address some of those, how we create plans that courts will usually follow, please contact us and let's see if we can work together. Another question that I get repeatedly comes up not only with me, but with all family law attorneys. That question is, what should I do if I suspect my child is being abused or neglected by the other parent? That is a great, hard question. First thing I tell each and every one of my clients is, if you think there is actual abuse going on, you should contact law enforcement. The reason being, most courts aren't up late at night waiting to hear from clients about allegations of child abuse or things like that. That is particularly a function for law enforcement to investigate and try and address as quickly as possible. So that's the first place. Again, I wish judges were up working 24 hours a day, but they are not. Right? That's the reality. The second thing I would tell you to do is to, if there is actual evidence that you can point to and point law enforcement to, whether it be law officers, child protective services, or some other agency, get the evidence to them as quickly as possible, because they are going to be interested Now, here is where this gets a little dicier. The courts generally discourage emergency hearings or ex parte hearings unless you can show immediate harm to a child. Abuse, neglect, extreme neglect, that probably does qualify, but you want to have your evidence in place. And when you can get to court as quickly as possible after you've contacted law enforcement, you want to make sure you can get the evidence before the court, make sure it's clear, and make sure it's credible. The reason why I say credible is because there are oftentimes people who make bloated claims, big claims of child abuse based on nothing more than suspicion. And what happens, there are times, and in California in particular, that person or parent or guardian or whomever, they could potentially be sanctioned for making a false allegation of extreme neglect, child abuse, or something along those lines. And what it can really do is harm you later when you come back before a judge, and then you need a close call because the judge is going to think you weren't credible. It happens all the time. If you know anyone who's been involved in a family law matter related to custody, calls to CPS are routine and don't carry as much weight unless the allegations are sustained. If the allegations are deemed to be true, then it creates a whole nother can of worms that a parent or parents may have to go through, potentially even having the child removed from both parents. So when you're making the allegations related to abuse, some type of sexual abuse, immediate harm, they got to be strong. They got to be credible. They can't be made up because it can really affect you going forward in the child custody process. Now, if you'd like to speak with us about how we can help evaluate those types of claims, look into them, and get your case before a judge with the aim of getting you the best custody decision possible for your child, please give us a call. Let's see if we can work together.